Hi, everybody. I'm Diane Brady. I'm here with Stuart Anderson, who is Executive Director of the National Foundation for American Policy, also a Forbes contributor. Stuart, nice to see you.
Thanks for having me back.
Well, we're talking about the gift that keeps on giving, H-1B visas. This time, the starting point is a court ruling related to the spouses of those visa holders. Tell us a little bit about the context of what's going on.
Well, in 2015, the Obama administration issued a regulation that allowed the spouses of H-1B visa holders to work if the principal H-1B had filed for their employment-based green card and been waiting a certain period of time. And basically two categories, but that's essentially what it was. A group called Save Jobs USA filed a lawsuit claiming that the Department of Homeland Security did not have the authority to issue that regulation and allow the spouses to work. At the same time, the same group, or a similar group, I should say, had filed suit in another court, saying also that the Department of Homeland Security didn't have the right to issue work authorization or extended work authorization for international students. So what ended up happening in both these cases is there was a long delay as the court even decided whether the folks filing the lawsuit actually even had standing to go ahead and file the lawsuit. Eventually, it was decided that they did have standing, and you had this case on the spouses. But what had happened in the meantime is that the spouses case ended up being largely decided on the basis of the international student case having been come out in favor of the international students and universities and their employers.
So it set a precedent,
and
basically.
Also the Department of Homeland Security on a 2-1 DC Circuit Court decision, saying that they did have authority to issue employment authorization to these international students. And so then when you look at this case, you'll actually see the judge actually says the plaintiff's primary contention is that Congress has never granted DHS the authority to allow foreign nationals like H-4 visa holders, the spouses, to work. But then the court says that the analysis of the WashTech case, which was the international student case, is, quote, directly applicable to this case. So really what happened was that another group called Immigration Voice intervened in the case to try to represent also the interest of the spouses, and companies and some associations also filed an amicus brief. And that gave the judge kind of a more rounded view than just having the group that opposed the rule have their point out there. But in the end, really what ended up being, decisive, probably overall, was the fact that a different decision had already decided that that DHS did have the authority, a very wide-ranging authority, to issue work authorization. And the judge applied that ruling to the spouses.
So, Stuart, I want to let's talk about the broader political context here. Of first of all, how big a cohort is this that we're talking about with the H-1B visa holders? I know it's always been coveted. It's always been a very political exercise in the first place with regard to how many that we let in under this visa category.
Well, there's about 85,000 new H-1Bs each fiscal year that can be hired by basically private sector employers, and there may be another 20 or 30,000 that come in through exemptions, depending on the year, for universities and nonprofit research institutes. In addition, those that piles up over a period of years. So maybe you're looking at up to 500,000 or so H-1Bs, but that number gets inflated because of the very high number of individuals who are waiting years in employment-based green card backlogs. And that's why this decision on the spouses was so important, because you're looking at 80 to 90,000 or 100,000 or more spouses that have the right to work under the regulation. And it's extremely important because you have people, it's primarily women from India, this ruling affected. And because of the per country limit, you have people from India often waiting a decade or even 2 decades and potentially even more because of this per country limit. I mean, Congressional Research Service estimates by 2030, you're looking at over 2 million who will be waiting in employment-based green card backlogs.
Well, it's interesting. So give us some context as to what situation employers are in, because this time last year, obviously, there was a lot of talk about talent shortages. Now this year, we're seeing layoffs in the tech sector, which I know is a big consumer of these particular visas. Does that make any difference here, or is this really the cohort that, in essence, are permanent residents and they're being held up by, the immigration facilities?
Well, for this cohort who's most affected by this decision, they are already been waiting for the green card probably years. For future people who would apply for green cards, this would also affect them. Our organization put out a report by economist Madeline Zavodny last year that recommended that the work authorization be extended to all H-1B visa holder spouses, which is really what the case is in Canada for their equivalent visa. And that would be an important reform. Many of these people, many of the spouses actually have this very similar education level to the principal H-1B, because that's the way life is nowadays.
Is that encouraging more couples, say, to go to Canada as a result of this?
Well, I think that's definitely what's been happening. As we were discussing earlier, the number of Indians going to Canada is astonishing over the past 10 years. The data that we've been able to compile from the Canadian Immigration Services is that the number of Indians immigrating to Canada has more than tripled since 2013. I mean, that's not the kind of movement that you would normally expect to see from one country to another, short of almost a refugee situation. But instead, what we're really looking at is people making rational decisions based on their education, their credentials, and their professional aspirations, that Canada has become a better place to build a career because of the smooth transition from being an international student to temporary skilled status to permanent residence in Canada.
Can you talk a little bit about the mindset, since we are in this, Democrat v. Republican era? Has there been much on the policy front with regard to this group, a difference in approach, certainly a difference in rhetoric, but an actual on-the-ground approach with H-1B under Biden versus Trump?
Well, in the executive branch, there definitely has been. I think there's been a number of initiatives from the Biden administration that have tried to make it somewhat easier for highly skilled. They had some initiatives on entrepreneurs. The denial rates were very high during the Trump administration, and as we talked about last time, there was a successful lawsuit before the Trump administration ended that brought the denial rates for H-1B visas down quite a bit. I think you've also seen some effort in Congress, last Congress, and in previous Congress, to try to eliminate the per country limit. Those efforts have not been successful. That would have helped at least lower the employment-based wait time for some people, particularly from India. But you also saw last Congress, the House passed a measure that would have exempted people with master's degrees in key technical fields and as well as PhDs, and that was blocked by Senator Grassley, a Republican from Iowa. and there weren't enough other Republicans who intervened to try to stop him from blocking it on the CHIPS Act, the semiconductor bill. And if that had become law, that would have been a very important competitiveness reform for the United States for attracting highly skilled people and, most importantly, retaining highly skilled people.
Is there any estimate as to what we lose with this ongoing debate and restrictions? And I know it's hard to put an actual price on it, but since we're talking about competitive advantages, how do you measure that in some way beyond the numbers of visa holders themselves?
Well, we estimated, for example, we've done some research on the Chinese visa bans that the Trump administration put into effect that affect people from China with PhDs and in some cases masters in computer science if they went to certain universities. And we estimated for every 1,000 of those people, of those individuals who are blocked, you're looking at billions and billions and billions of dollars in lost economic output for the United States because of the innovations that those people would have created. And so if you translate that into other people who are going to Canada, to China, and other places, and we see that that's exactly what happens. You're looking at tens of billions more, hundreds of billions likely when you add it all up, depending on the time frame. I have an article coming out shortly on the updated research by Britta Glennon that looks at what happens when companies are denied H-1B visas or restrictions are put on them, and what she found is the companies send the people to Canada, and they send them to China, and they send them to India.
Yep.
And they expand the resources there. So these types of restrictions don't end up, quote, protecting American jobs. What they do is send more jobs and resources outside of the United States.
So on a tactical basis, if you are the spouse of H-1B holder who is in that process of waiting to get a green card, is this ruling have an immediate impact, or what advice do you have to those who are in the system?
Well, I think it certainly has an impact if you have a spouse and you were planning on having to stay in the United States for a number of years, because not only for raising a family, but just from a human rights perspective, the ability to work is really a pretty basic right. And particularly if someone has the same education level as their spouse, it's really unfortunate to have rules in place where the spouse is unable to work. But I think that at a more practical level, that the biggest problem for highly skilled individuals who graduate U.S. universities is trying to get an H-1B when you only have 85,000 H-1Bs a year, and you're looking at, generally speaking, maybe up to 500,000 H-1B registrations are selected or would need to be selected to meet the demand. And so what happened in the last fiscal year is over 400,000 of the H-1B registrations did not result in someone being hired. We don't have the numbers yet for this year, but even with some of the tech layoffs, the 85,000 limit is so low that one would expect that there are going to be many, many individuals who are going to be disappointed, right, and their employers will be disappointed as well.
And they have to go somewhere. Thanks for joining us, Stuart.
Thank you.